It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning, and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law, and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as protecting money from nursing home stays, securing benefits from programs like Medicaid and the VA, the geriatric care coordination through our elder care coordinator, estate and trust administration, guardianships, and planning for those with special needs. Nugen Law sees clients in many stages of life, but commonly we have folks reaching out when they or a loved one are showing signs of needing help. Those signs may include a chronic ailment or progressive decline, before, during, or after a hospitalization, an instance of incapacity, caregiver burnout, stress on family members due to some or all of those instances I just mentioned. As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting for either our Fort Wayne or our Auburn locations. You're also encouraged to see us online at www.nugenlaw, that's NUGENLAW.com. Also to our listeners, we will be presenting a free seminar on August 15th between 1 and 5 p.m. in Fort Wayne with a deeper dive into how you can be sure to preserve your dignity and protect your money, with topics like asset preservation, care management as you age, estate planning, and elder law. Please give us a call, 260-925-3738. That's 260-925-3738 to reserve your spot. Today, I have a member of the Nugen Law interdisciplinary team, attorney Jesslyn Smith, here in the studio. Jesslyn is licensed to practice law in Indiana, has been doing so in excess of a decade, currently president of Indiana's chapter of the National Academy of Elder Law Attorneys. She's knocking it out of the park there. So, Jesslyn, welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging. Jesslyn, please start by telling our listeners what brought you to the practice of law and, more importantly, estate planning and elder law.
Well, thank you, Bryan, for having me today. And what brought me to the area of law that I am practicing in? Well, when I was younger and in my undergraduate studies, I realized I wanted to find a couple of different areas to try out before I actually went back to law school. So I worked for a couple of different law firms, also worked at the courthouse here in Allen County for a little bit, and then started at a firm that practiced elder law. And I just really fell in love with that area of law and how we help folks protect what they've worked hard for. And I knew then that I was ready to go back to law school. And so I went to law school on the weekends while I worked full-time and passed the bar in 2013 and have been practicing since in elder law, and I love it.
I think what I enjoy about elder law is that I really feel like I'm benefiting folks. I feel in my heart that I'm doing good work for people and getting accomplished things that they know they wanted to have in place but maybe weren't sure how to do it. We're protecting them on many levels, financially, personally, etc.
Yeah, it's rewarding to feel like you're accomplishing something for your clients in which they know their wishes are going to be honored, and knowing that you've helped them do that, it's rewarding to me.
So some of our listeners may not be aware, and even when I use the phrase, they'll say, what is that? What elder law? What is that? So how would you define elder law generally?
Generally, I would define elder law as dealing with folks that are aging and helping them through that process. That's how I would describe it generally, because there's a lot that is really involved with when you're talking about elder law. There are different areas of law that even tie into that. For instance, estate planning comes along with elder law and helping them get those proper documents in place. And then we've also got the medical side of things that folks may be dealing with. And so elder law is just, in general, I would say, helping those that are aging and helping them navigate that.
You mentioned estate planning. I do like to draw a distinction. Estate planning is so every elder law attorney does estate planning. Every estate planning attorney does not do elder law. So if you're looking for something that really is unique about asset preservation, securing benefits, you'd want to speak to an elder law attorney to make sure that you're really getting the depth of knowledge that elder law attorney, somebody like yourself, Jesslyn, at Nugen Law, would have. You have mentioned a couple of times, and this can be a little confusing too, that elder law, and we talk about folks as they're aging, but actually we also could work in the arena of special needs. So special needs individuals, they could be a younger person, not somebody that you would chronologically say they are elderly or seniors. So let's talk about how special needs individuals fit into the practice of elder law as well.
Yeah, so special needs individuals are those that may have a disability or maybe even some type of cognitive impairment, at an early age, but they've got something that has impaired their ability to, say, maybe work, or even to be able to provide for themselves. And so a lot of times with those special needs individuals, we look at how can we secure benefits for them as well.
So why is it that we must pay attention to how we manage or handle the funds of those with special needs? What happens if they have immediate access to money?
If they have immediate access to money, it can affect their ability to maintain or keep their public benefits, because certain public benefits are what we call means test based, and that means that it's based on how much you own or have access to. So in order to help those individuals qualify or maintain those benefits, we have to look to certain instruments that we prepare in order to protect assets, and we do that through special needs trusts.
So let's talk very generally. Trusts, I think people oftentimes, they hear that word and they think of the Rockefellers, and they think of this multi-generational trusts, and gosh, I'm not a multi-millionaire or a billionaire, that this is beyond me. But frankly, those trusts, especially for folks with special needs, are very important. So let's talk about what a trust is, and then what it does for the individual that has special needs.
Yeah, so the trust is a contract that says there's going to be a trustee that manages and handles this money. And then it says where does the funds go after that person with the special needs passes away. So in general, that's what the trust does. And then there's certain language within the trust that makes it exempt in order for them to have the public benefits and still have the funds set aside in that trust.
So great definition. I'd like to think of it as you're putting funds either the individual, the client that we're working with at Nugen Law that has a special needs, we're taking their money and putting it into this type of a trust. Or we could have an outside person, a parent, a grandparent, a sibling, could put money into another type of a special needs trust. It's a little unique because it's coming from outside monies. So the monies are put into this envelope. They're still there for the benefit of the person with special needs, but it's not looked at by that source, that payer source. It could be a Medicaid, that they're looking to determine what access do you have to your money. By putting it into that unique type of a trust, they can still get those public benefits. And by the way, those monies are there for their benefit. So if the trustee determines money should come out for their benefit, money can come out. So it doesn't go anywhere, doesn't disappear. It's still there for you, but it just opens doors for other benefits that you may be to which you may be entitled. What does a special needs trust do for your special needs clients? How does it differ from, say, a living trust or an asset protection trust? How is that different?
Yeah, so the special needs trust is meant to be for the benefit of that individual with the special needs. And so the benefit while they're alive is only for themselves with that. Whereas with a revocable living trust or an asset protection trust, you may have someone else that could be receiving the benefit out of those trusts. Sure. So I think that's the easiest way of describing what the difference is between those. Also, with the revocable living trust, usually the person creating the trust is going to serve as their own trustee until they're unable to, and then they usually have a backup trustee that is put in place. And then with the asset protection trust, there is also usually another trustee that is serving as the trustee of that trust. And so it differs in that as well.
So it differs in who's managing the money, how the monies can be used, and frankly, depending upon the type of trust that you have, some shelter those assets so that you still can get public benefits and some don't. So it's important to speak to someone like you, Jesslyn, an elder law attorney that would be able to fully define this is the appropriate type of trust for you, considering these set of facts, and it would benefit you the most. I will sometimes have clients in the office, parents, grandparents, that will say, I'm not going to give money directly to my child. I'm going to give it to another child, and they promise me they're going to manage that money for the benefit of their sibling that has special needs. So that one kind of always brings the hair up on the back of my neck. We don't need to do that. You don't need to trust that the one sibling is going to manage this money for the next 20, 30, 40, 50 years for the benefit of their sibling. There are specific trusts that we can use to not only benefit the child with special needs, but to make sure that the money is there and protected for a lifetime.
Yeah, it's very common to hear clients come in and say that I need to disinherit this child because they're special needs and I don't want them losing what it is that they're receiving. And I'm just going to trust my other kid's going to take care of them. Right. And it's a relief to them when I can say, no, we can set this aside and guarantee it is set aside.
Well, let's not forget, too, the child that you are entrusting to manage the money, if you just gave it to them, things happen in their lives as well. They may have a divorce. They may pass away unexpectedly. They may have a disease or a disability. So all of those, they may have debt, right? They may have credit card debt, or they get sued for this or that. So it doesn't work for the individual that's holding that money to say, oh, this really isn't yes, the account's in my name. I have access to the money, but it really isn't mine. I'm holding it for my sibling. That doesn't work. You're going to lose it in the divorce. You're going to lose it if you get sued. If you have a death, I assume that your estate plan is saying my money is going to my spouse or to my kids. So we're looking at the money being dissipated and not being there as the parent or grandparent had originally intended. So those special needs trusts are key. When we're talking about trusts, we have phrases like grantor, trust maker, trustee, beneficiary. What are each of those roles and what do they do?
Yeah, so the grantor or settler is the person creating the trust, or what we like to refer to the person creating that contract. So they're the ones deciding all of the terms within that contract too. Who's going to receive it, who's going to manage it, and so forth. The trustee is the person that the grantor selects to manage the money. And so the trustee is the one in charge of that money and making the distributions and taking care of that. And then the beneficiary, there are two types. There's lifetime beneficiary, so who's receiving the benefit while they're alive. And then there's death beneficiaries, who gets the money after someone dies. And so, and they can be different folks, in fact, especially with the special needs trust. Usually the special needs individual is the beneficiary while they're alive. That's the lifetime beneficiary. And then the death beneficiary is who did the grantor want the money to go to after they passed.
So when folks are coming in to speak with you, Jesslyn, at Nugen Law, they've made an appointment, they're coming and speaking to you and asking about these things. It would be nice if, in advance, this is my experience at least, that they kind of have in mind individuals that they may put in some of those categories. Now, if they don't, we can help guide them and we can make recommendations, and there are even outside sources that will serve. But those are some things that our listeners may be thinking about. Gosh, I might want to set something up like this. Who would I want to have managing the money? Who is it? What are the terms of that? When my loved one passes away, where's the money going after that? So we want them to think about all of those things. As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting for either our Fort Wayne or Auburn locations. You're also encouraged to see us online at www.nugenlaw.com. We will also be presenting a free seminar on August 15th between 1 and 5 p.m. Jesslyn will be there along with the rest of the Nugen Law team and lots of vendors. That presentation will be held here in Fort Wayne. We'll be taking a deeper dive into how you can be sure to preserve your dignity, protect your money, with topics like asset preservation, securing benefits to pay for your care as you age, care management as you age, estate planning, and elder law. So please give us a call, 260-925-3738, to reserve your spot. If Jesslyn, if someone agrees to serve as a trustee, are they personally responsible for the debts of the beneficiary, the special needs person? Do they have to personally pay income taxes for any income generated by the trust? Those are questions that I receive regularly as well.
Yeah, no, those are really good questions too. But no, they're not personally responsible for those. Just because you serve in that role doesn't make you personally responsible. Unless you have mismanaged that money to the effect of maybe stealing it or things like that, then you can make yourself liable. But if you are using the funds in the trust for the special needs individual or the beneficiary, then you're serving as your duty, which doesn't make you personally liable.
Great. So let's continue our discussion with special needs folks or folks that may need a little bit of oversight for some type of normally a cognitive issue, right? Their cognition, their thinking isn't as clear as it could be. They have some level of an incapacity. I want to discuss something which could be related to special needs clients, and that's guardianships. Guardianships, Jesslyn, what are they? When are they appropriate? How do they work?
Yeah, guardianships are when an individual does not have a power of attorney selected to make financial decisions for them or to handle maybe healthcare decisions for them, and that person is incapacitated and unable to sign documents now. And so we have to go to court and ask the court to appoint a guardian for someone to make those decisions.
So let's walk through that process of establishing a guardianship. What are some of the first steps that need to happen?
Well, usually I meet with the clients for the initial meeting, and we go through and actually talk through that process. We have to file paperwork with the court, which is known as a petition for appointment of a guardian, and that simply is saying to the court, this individual is incapacitated. We've considered trying to use other means in order to handle the situation. And we're unable to do that, and so we need to get a guardian appointed by the court. So we ask them to set a hearing then, and then we have to give notice to all interested individuals in the situation, and usually that's going to be a spouse, if you have any, your adult children, and maybe adult siblings in the situation. So we send out that notice at the same time we're filing the petition, and the court will set a hearing. And so then we go to the hearing.
And the person that we believe should be the subject of a guardianship, they receive notice as well?
Yes, they receive notice as well. It's required by law because essentially we're asking the court to strip them of their rights. Mm-hmm. And so it is a due process issue that we have to give them notice.
If a potential ward of a guardianship is under 18 years of age, do we need to go through this process?
Yes.
Okay.
Also.
All right.
Yep. And we see it commonly with children that may have a special need, and they're getting ready to turn 18, and we go ahead and file, with the court a couple of months before their 18th birthday, because it usually takes a month or two to get a hearing, and then that way we're already ready to get that put in place when they turn 18.
And can the court establish a guardianship without speaking to a medical provider or a doctor, or is a medical opinion required to determine whether or not somebody is appropriate for a guardianship?
It's required, yes. We always have the family obtain a physician's report. Otherwise, then we either need to collect medical evidence, such as medical records to submit to the court, or even subpoena the doctor to come in for the hearing if they refuse to fill out the physician's report.
We have heard horror stories, right, in the news about people being subject to the guardianship that shouldn't be, and that medical opinion is part of the process to make sure that it really is appropriate. And let's not forget that the person that is potentially subject to the guardianship also has representation. And that's somebody called a guardian ad litem, or GAL, G-A-L, guardian ad litem. So what is the guardian ad litem? What's their role, and how do they benefit the person that may be subject to the guardianship?
Yeah, so the court appoints this guardian ad litem, which is usually another attorney that is going to understand the rules and the laws in order to look out for the interest of the ward or incapacitated adult. And their specific role is to be a neutral third party in the matter and make sure that who's petitioning the court is suitable, and also make a recommendation to the court if they believe the individual does need a guardian. And so they file a report with the court, or they even come in for the hearing also, and they testify as to their report to the court and say yes or no, this person needs a guardian, and yes or no, the person that's petitioned should be the one chosen.
If this discussion of special needs clients and guardianships resonates with you, and you would like to meet with Jesslyn or another of the team members at Nugen Law, please give us a call at 260-925-3738, or send a message to us through our website, www.nugenlaw, that's NUGENLAW.com. You can also text the word Nugen, N-U-G-E-N, to the number 45364. So on your smartphone, if you text NUGEN to the number 45364, you'll receive our contact information. You may also consider coming to our free seminar on August 15th here in Fort Wayne. We'll take a deeper dive into how you can be sure to preserve your dignity and protect your money, with topics like asset preservation, securing benefits to pay for your care as you age, care management as you age, estate planning and elder law. Please call 260-925-3738 to secure your spot. Jesslyn, back to our topic of special needs and guardianships. After the court believes it to be appropriate for the person to be the subject of a guardianship and a guardianship is established, what's the ongoing process thereafter?
The ongoing process is that the guardian has to file an inventory telling the court what is it that the ward owns. And then every 2 years after that, an accounting is supposed to be filed with the court so that the court can oversee what the guardian is doing with the funds and making sure that they are utilizing those funds for the benefit of the ward.
Is there every time the guardian provides payment for something on behalf of the person subject to the guardianship, do you need to ask court's permission for that? When do you need to ask for the court's permission? In what instances do you not need to ask for the court's permission?
Usually you don't have to ask for the permission if the court has given all general authority to the guardian in order to handle and manage paying the bills and taking care of the assets of the ward. However, there are certain instances in which you do have to ask permission if you're looking to sell the real estate of the individual or transferring the real estate. You have to ask the court's permission to do that. So the court and the statute, the statute says that you have to petition the court and ask to do that. But otherwise, there's usually not too many restrictions on it unless the court set initially limitations on the guardian. If the court did set limitations on that guardian, then it may be possible that you would have to petition the court to ask to do things.
Well, I think that should give folks some level of comfort as well. There is, although it's not daily oversight, there is oversight. There's an accounting that needs to be submitted to the court. And the court has the opportunity to review it and say, hey, wait a minute. I don't think you're within the lines here. There may be an issue going on, which does happen. But we're trying to put those safeguards in place so we're limiting those instances. And frankly, the people that are typically serving as a guardian have the best interest of the ward, the person subject to the guardianship at heart. And you don't see theft taking place with great regularity. It does happen, but that's not the norm. That's more the exception. At least that's been in my experience. How do we make sure that we are avoiding establishing a guardianship for someone who may not really be appropriate for one, right? The Britney Spears events of the situation, at least that's the most recent decision by the court in California. How do we make sure that somebody isn't subject to a guardianship that really shouldn't have been? They're appropriate to be acting independently.
Yeah, we talked to them then about getting their powers of attorney in place and their healthcare representative designations in place, because if you have the capacity and understand that you can pick who you want to manage your funds and make your healthcare decisions, then you can have those documents in advance. And so if something happens to you, they don't have to petition the court then in order to get that authority to act.
Well, and the law in Indiana as well is if there's a less restrictive means of being able to provide care for someone than a guardianship, the court wants to look to those. So they want those powers of attorneys in place. They want the healthcare representative designations to be in place so that if we can avoid having that full-blown guardianship, we do so. When's a good time to have the POA, that healthcare rep, prepared? When's a good time for that?
I say anyone that's over 18 should have one.
Yeah.
You
How
never
often
know.
are you preparing these for clients, Jesslyn?
Every day.
Yeah, daily.
Yeah.
And it sounds so vanilla. Oh, power of attorney, healthcare rep. To me, those documents are as important as anything else. You don't realize it until you're in a situation where somebody's health has declined and now we need a guardianship. And you, as you mentioned earlier in the show, it doesn't happen immediately. The court doesn't, you file the petition, the court signs it that day. No, it can be months for it to happen. So we don't want to have our folks in a situation where they didn't think in advance to put those things in place. I in concurring with you, Jesslyn, and at 18, you should have that in place. The student going off to college should have those things in place. As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast which resonates with you, please give us a call, 260-925-3738. Speak with one of our intake specialists and schedule a time to meet with myself, Jesslyn, another member of our team at Nugen Law. Nugen Law will be presenting a free seminar on August 15th between 1 and 5 p.m. in Fort Wayne, taking a deeper dive into things that we've spoken about today, among other items. Give us a call at 260-925-3738 to reserve your spot. Our time is running short, and we need to wrap up our discussion with Jesslyn Smith, one of the attorneys with Nugen Law. Jesslyn, thanks for being on. And thank you, listeners, to hearing our broadcast today, Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. Look forward to speaking with you next weekend at 9 a.m. Enjoy your weekend.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to NugenLaw.com or email help@NugenLaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.
Podcasts by Federated Media.